So if you might need to speak up a little more than normal. I think the recording is still going out so that it'll be broadcast live on the AOC website unless we put an order down saying otherwise. And then we'll be on the AOC, oral argument on the AOC website. I think that part's still working. So just keep that in mind as you're talking to us. Call the first case, please.
Automotive LLC v. Motohaven, Automotive Group, LLC, et al.
We'll hear from the appellant.
Good morning, Your Honors. Alan McDonald of the Knoxville Bar for the appellant Quality Motors, LLC. I would like to reserve 5 minutes for my rebuttal.
That'll be fine.
There are, I think, multiple issues in this appeal, but the central issue is the ownership of 14 automobiles, which are the subject of the complaint at the trial court. This court established a 7-factor test to determine ownership of a motor vehicle. However, that test was not applied by the trial court. And in fact, the trial court made no findings of fact whatsoever relative to those 7 factors. We are asking that this court review the record, apply the correct standard, the 7-factor test, and find that the preponderance of the evidence is that Quality Motors, the appellant, owned those 14 vehicles, and to remand the case to the trial court for a determination of damages. Quality Motors is a limited liability company. It is it owned and operated a used car lot in Knox County, Tennessee on Clinton Highway. One of the defendants, Mr. Ali Khalil, was a general manager for Quality Motors. Mr. Khalil sold or otherwise disposed of 14 vehicles, 4 of which were sold to the co-defendant, Motohaven. Mr. Khalil instructed Motohaven, rather than to pay Quality Motors, to send all of the proceeds of the sale to his brother's limited liability company in the state of Georgia. The Quality Motors owner, Mr. Chris Yusuf, who is in the courtroom, went to Motohaven demanding that Motohaven pay him. Motohaven refused, said that they had acted under the instructions of Mr. Khalil, and that led to a lawsuit being filed first in General Sessions Court, and then it was ultimately transferred to the Circuit Court of Knox County. After the case was transferred, there was a lot of discovery. The case was probably litigated for 3 or 4 years in Circuit Court. There was a trial April and May of 2023. At the end of the plaintiff's proof, Judge Ayler determined that the plaintiff had not met its burden of proof as to the defendant, Motohaven. That is, that Judge Ayler said that Ali Khalil, the defendant, had the authority to sell the cars at issue to the co-defendant, Motohaven. Judge Ayler expressly refused to or did not consider what Motohaven did with the money and whether Khalil had the express or implied authority to direct payment to be made to the LLC owned by his brother in Florida. In Georgia.
Counselor.
Yes, Your Honor.
How do we get around or deal with the trial judge's ruling on credibility?
Well, the judge made a lot of decisions regarding the credibility of witnesses, I think frankly, which were not favorable to either side. But the issue is really not in this case the credibility of the witnesses. It is about the credibility of the documents which were received into evidence, most of which were from non-parties.
Well, the trial court had a problem with that with your client too, didn't they? That the trial court found plaintiff throughout the trial attempted to introduce evidence has not been produced to defendants. He contradicted his prior testimony that he did not have those records. And in other words, he didn't produce these records, and then at trial he had the records. And the trial court went on to say the court's determination is the plaintiff was willfully false throughout his testimony. Now that applies also to the documents, doesn't it?
I do not think that it would apply to the documents that were received, one from the Department of Revenue. Those were turned over because I requested those, and I will add that I took over this case for Knoxville attorney Scott Jones. And when I took over the case, I saw that there had not been a records request that had been made by the Department of Revenue. That's one of the first things that I did. I got a full records request on all 14 vehicles at issue, and then I immediately turned those over to the defendant. So I don't think that there can be any issue at all regarding those, nor can there be any issue concerning the documents that were received from the third-party finance company, the floor plan company, which was Nextgear, which floor planned all 14 cars at issue. Once again, as soon as I got involved with the case, one of the first things I did, I sent a subpoena to Nextgear, obtained all of their records, not only for these 14 cars, but for every car that it had financed, and I turned all of those records over. So there can be no issue regarding the disclosure of those. And what I think that Judge Ayler was referring to regarding the records were not the records of these cars. As soon as the lawsuit was filed, Scott Jones had all of the records for those 14 cars. Those were all maintained and kept. Where the issue came was during the discovery phase when the defendants had asked for records of all of their inventory for a lot of cars which were not at issue, and those records had not been retained. A lot of them were on, I think, outside third-party vendor maintained software called Frazier, and since Quality Motors was out of business, the Frazier software was not kept up to date. The fees weren't paid, and those documents were no longer there. And somebody, I believe, came in and took records from Quality Motors for other cars that were not these 14 cars at issue. But there was, early on in the discovery phase, requests for all documents related to these 14 cars, and those were provided. And there should not have been any issue about turning over records regarding those cars. And frankly, I think that the trial court conflated the issue of providing the records for the 14 cars at issue and the other ones, which there were some records, and those records were not ones that we said, frankly, that we didn't have. Those were some bank records at issue regarding the cars. And I didn't, and Mr. Jones did not believe that those records were really part of the request for production of documents that were made by the co-defendants. Judge Ayler looked at the request, and he frankly came to a different conclusion, and therefore that's why he would not allow those records to be introduced. However, I didn't even make an attempt to introduce those records because when Mr. Khalil testified, he testified that all of the payments made on the cars when they were paid off were made from Quality Motors bank account. When I got that admission from him on cross-examination, I didn't even need the bank records. The bank records would have simply said payments were made from Quality Motors' bank account. Mr. Khalil admitted that. So therefore, I didn't make an offer of proof, and I dropped the issue at that time.
Were there any written agreements between the parties?
None.
None. Thank
No.
you.
I've only got 15 seconds left, so I don't think I can really say anything more from that, but if the panel has any questions, I'll be glad to answer those right now.
Here none, you have your time for rebuttal.
Very good, thank you.
Thank you. We'll hear from the appellee.
Good morning, Your Honors.
Morning.
I'm Kathy Morton from Blount County, as you all know, and I represent Motohaven, who was a used car business at the time in Maryville, Tennessee. The facts of this case will show that my client was dragged through the mud for 7 years, incurred unnecessary cost, expensive cost over extended litigation, continuances, failure to comply with the discovery, the behavior of Mr. Joseph and his attorney. He had to undergo what was uncivil remarks in the hallway by Mr. McDonald. There was ended up with a report to the Board of Professional Responsibility. But in any event, the facts in this case show that my client, Motohaven, purchased vehicles through Mr. Joseph, who was the owner of Quality Motors, agent Khalil Hussein. Sometimes he's referred to this record as Ali, sometimes Khalil, and sometimes Hussein. So to clarify who we're talking about. He paid for those vehicles in accordance with Mr. Joseph's Quality Motors agent's instructions. He keeps saying he was told to send them to his brother. That's not the fact. He was told to send the funds, and the funds were wired to a holding company, which Jeremy Taylor, who was the general manager for Motohaven, testified was customary and standard in the business. He had worked before for Mr. Joseph. In the defendant's brief, he admits that he knew and had gone to Motohaven's lot. Mr. Taylor told Mr. Joseph that Motohaven, he had on behalf of Motohaven and negotiated for the sale of these vehicles, and that Mr. Gugliotto, who owned Motohaven, paid for them. He came to that lot 2 or 3 times, according to Mr. Taylor, and at some point demanded that Mr. Gugliotto for Motohaven pay him again for the vehicles. He was aware that my client had purchased them. There was no evidence that they weren't purchased for fair market value. And then he goes and files a lawsuit claiming that my client wrongfully possessed 14 cars, when he knew and he testified there were only 4, and 3 of them had been returned to him. So for 7 years, we defended this allegation, not only that we wrongfully possessed these vehicles, but that we had fraudulently converted them to our own use against his rights. As I told you, the proceedings were long and contemptuous. They failed to produce documents. He testified in a deposition he didn't have any documents, and 2 days before trial filed an affidavit that said, here are the records kept in the ordinary course of business. Then he gets on the stand and lies, as the court pointed out, over and over and over, and his lawyer even stood up and said, shut up. We go out in the hallway, and his lawyer comes out and tells my client to get...
Well, forget what happened in the hallway. That's not in the record.
Okay.
I mean, you're well
Well-
aware, all we can look at is what's in the record before us.
Well, in
If
the
if it's
record,
not in the record,
in the record was whether there had been a violation of the professional rules.
okay.
We believe that the trial court's entitled to a presumption of correctness. There was no evidence whatsoever that Motohaven wrongfully possessed these vehicles. There's no evidence ever that they converted the vehicles fraudulently. Mr. Joseph confirmed that Mr. Ali Hussein had his authority. Not only, he was the general manager. At one point, he said he didn't have the authority to sell the vehicles. At another point, he said he did. It was all over the transcript. The court then, at the conclusion of the case, awarded, we asked for exemplary damages under the statute for possession of personal property. The court, as exemplary damages, awarded the attorney fees and costs incurred in the circuit court case, not the general sessions case. Mr. McDonald wants to change the issue. He said he wasn't trying that case for possession of personal property under that statute, but only for fraud and conversion, when in fact he had alleged that in his complaint. And we tried the case on that, as the trial judge pointed out. But in either event, he failed to carry the burden of proof, at least as to Motohaven. Thank you.
Hear from the appellant, or excuse me, you all divided?
Yes, Your Honor.
Okay, I'm sorry. Go ahead.
Good morning. May it please the court. I'm Rachel Sanders, and I, along with Carol Beeler, represent Ali Khalil. Quality Motors has asked this court in its initial brief to use what we believe is the wrong standard of review in stating that the underlying court made no actual findings of fact. And then after Ms. Beeler and myself and Ms. Morton briefed it and pointed out that there was a 12-page memorandum, very detailed, where Judge Ayler goes in to describe not only what each witness testified to, but their credibility, and went into great detail about the findings of fact, Quality Motors comes back and states, well, there maybe had been limited findings of fact. This back and forth is what Your Honors will see in the transcript, what happened in what was a 5-day trial, where Quality Motors would change or misrepresent things to the court throughout the duration of that trial. It's our opinion that an 11-page memorandum that outlined every witness's testimony in detail and addressed the witness's credibility was, in fact, very much so a detailed finding of fact. The trial court, as Your Honor has stated, is best suited to hear this and make this determination of the credibility of the witnesses and the documents, and he did, in fact, do that. So it's clear based on the evidence introduced at the end of the appellate's proof, along with the testimony of Mr. Youssef, that it was inconsistent, it was evasive, it was contradictory, and the trial court had sufficient evidence before it to rule in the way that it did and made a detailed finding of fact. Should the court think otherwise, that Quality Motors is entitled to a different standard of review that they're asking for, I want to reiterate some of the facts before the court. Our client, Ali Khalil, as the court I'm sure has seen in the record, prior to joining fronts with Quality Motors, owned his own dealership. At that time, he was approached by Mr. Youssef, who said he needed some help, and our client closed down his dealership, placed some cars of his on Mr. Youssef's lot, on Mr. Youssef's floor plan, and closed off his lot. His testimony was that, of course, the cars that were being purchased had Quality Motors' name on them because you have to have a dealer's license to purchase vehicles. His testimony was corroborated by 3 other independent witnesses, one which was subpoenaed by by Quality Motors, and they chose not to call him. The witness that the court says finds very credible, that had been in the business for 30 years, that this was in fact the agreement between Mr. Khalil and Mr. Youssef, that he was going to help this business. He was able to buy cars cars for himself, and they were in Quality Motors' name. In fact, there was another witness who even testified that he as well purchased cars for himself in Quality Motors' name. So they bring up the issue of ownership and talk about, well, these cars were titled in Quality Motors' name, and the court addressed that in its memorandum and stated, yes, these cars were titled in Quality Motors' name, but the court had to look at the intent of that relationship, and it was very clear through the evidence that these cars were not just Quality Motors cars. The credibility was a huge factor in this 5-day trial, and even motion hearings where we had to address Mr. Yusuf's failure to tell the court that he had filed bankruptcy. We had a motion hearing on that issue. Credibility across the board was an issue, and it's important to point that out, that this was very much so a he said, she said trial, and the court did find issues with credibility on the witnesses, even on our client to some extent, but found that when he was talking about the purchase of the cars, that he was calm and collected. But it's important to note that the one witness who the court found very credible, Jeremy Taylor, that he had been in the business for 30 years, he had worked for not only our client, but also Mr. Yusuf, and he agreed about the arrangement that they had. He agreed that our client could purchase these cars, that they were his cars, and he was credible. The documents are a big part of this brief by the appellant, and he outlines almost every car and addresses, well, this document shows this and this document shows that. But it's important for the court to note that each car at trial had almost 2 sets of documents, what we said were the bills of sale and what he said were the bills of sale. It's important to note, too, that some of the bills of sales that plaintiff tried to introduce had dates on them, dates that happened after we had already left Quality Motors. It's important to note that there's also a misspelling of our client's name on some of them, which the court took note of and had concerns with. It's also important to note that there was testimony and that some of these records, when Mr. McDonald's talking about the floor plan, some of these cars were on 2 floor plans. And there was testimony about where they would pay a car off on a floor plan and put it on another floor plan. So the records that Quality Motors addresses in their brief or points to in their brief are also not necessarily credible, and the trial court had that ability to look at the huge, the vast volume of documents at the trial level and address the credibility of not only the witnesses, but also those documents, the bills of sale that he refers to in his brief. As far as the attorney's fees go, I would just refer to my brief on that. I'm sure that we would have a collection issue with that anyway, but would refer to our brief on that. But just the ownership issue, the plaintiff had the ability to bring up, he talks about that 7-factor test. There was no proof of insurance or any of that at trial. The only proof that was entered at trial were these titles, which the court did address that those were in Quality Motors' name, and then he went on to look at the intent of the parties. So based on our brief, we believe that the trial court entered into the right decision on this, and that the court should defer to that decision. Thank you.
Thank you, counsel. Now we'll hear from the appellate rebuttal.
Thank you. All of the things that Ms. Sanders just spoke to, those are things which could have and possibly should have been in the trial court's findings of fact. There was a lot of testimony on those issues. The problem is Judge Ayler, in his decision, he didn't refer to any of those. I mean, we can look at the 7-factor test, and that was announced first, I think, in the case that we cited, Cunningham versus Department of Safety from 1997. In that case, I did some research yesterday. That same 7-factor test has been repeated by the Court of Appeals at least 5 other times. These are the 7 factors. 1, the circumstances surrounding the vehicle's purchase. We know what that was. Mr. Khalil went to auctions, went to places like CarMax and purchased cars, and every time he did, he put it in the name of Quality Motors. Registration of the vehicle. These vehicles were placed on the floor plan. They were always in the name of Quality Motors. Number 3, all aspects of insuring the vehicle. Next Gear had a requirement for insurance. We can presume that they were insured. We did introduce Mr. Khalil's tax returns for 2017 when these vehicles were sold. There wasn't anything about insurance. He didn't pay a nickel's worth of insurance. He didn't pay any interest, and he didn't pay any rent. We know that from the documents. All parties' financial stake in the vehicles. These were on Quality Motors' floor plan. Chris Yusuf personally guaranteed Quality Motors' floor plan, not Mr. Khalil. The actual possession of the vehicles, they were on Quality Motors' lot. Quality Motors' lot was owned by Chris Yusuf and his wife. That's in the record. In fact, it was brought out by defense counsel. Responsibility for bearing the expense of maintaining and licensing the vehicles. That was done at Quality Motors. There's not any evidence that Mr. Khalil paid any money for any of these vehicles, and the ultimate right to control the vehicles. They were on Quality Motors' lot. Chris Yusuf was the sole owner and the manager of Quality Motors. He was the owner. He controlled these vehicles. And to the extent that Judge Ayler thought otherwise, he should have put down specific findings of fact regarding these 7 issues. Regarding Jeremy Taylor and Jeremy Taylor's testimony, I think it's worth pointing out that when Ms. Morton wants to rely upon Jeremy Taylor's testimony for her client, Jeremy Taylor testified for Mr. Khalil after Judge Ayler had already ruled for her client. Judge Ayler didn't even have the benefit of that testimony when he granted the directed verdict for Motohaven. Since that was the case, I didn't bother cross-examining him on issues that at that point were moot. And so there may be some things in the record about what Jeremy Taylor said, but it didn't impact and it wasn't relevant to
Why did the trial court take proof after a directed verdict? It was a directed verdict at the close of your plaintiff's.
Directed verdict for only one of the defendants. It was a directed verdict for Motohaven,
All right.
not for Mr. Khalil.
Okay.
Finally, I know I've only got 30 seconds left. There was a discussion about other people buying cars and using Quality Motors to purchase vehicles. That may have happened, but they were never kept in the name of Quality Motors. Somebody said, I'm looking for a 2014 Toyota. Would you buy me one? Yes, we'll buy one. Those were always immediately transferred out. There's no indication that anyone purchased and kept cars for an extended period of time in Quality Motors' name. If there's any questions, I'll be glad to answer those, but otherwise, I think my time's out.
I hear none.
Very good, thank you, Your Honor.
Of course, thanks to counsel, both sides. We appreciate your argument this morning and your briefs on this matter.